Viramontes versus Cook County and Grant versus Higgins, granted June 30th, 2026. Folks, there are two things happening here, and I want you to hold both of them at the same time because most of the coverage you've seen is only telling you one. The first thing, on June 30th, 2026, the last day of the Supreme Court's 2025 to 2026 term, the court agreed to hear Viramontes versus Cook County and Grant versus Higgins, consolidated into a single case on a single question: whether the Second and 14th Amendments protect the right to possess AR-15 platform and similar semi-automatic rifles in common use for lawful purposes. That is the question. Stated that precisely, written into the order granting cert. The second thing, and this is where I need you to stay with me, every assault weapon ban currently on the books in every state that has one remains fully in force right now. The cert grant does not suspend a single law. It does not pause a single prosecution. It does not change what is legal to own in California, Illinois, New York, Maryland, New Jersey, Connecticut, or any other banned state today. Virginia's ban took effect July 1st, 2026, the day after cert was granted. Colorado's takes effect August 1st. What the cert grant does is set the clock. Oral arguments are expected in the fall, likely November or December 2026. A decision is expected before the term closes in June 2027. By that date, the most important Second Amendment question left open since Heller was decided in 2008 will have a final answer from the Supreme Court of the United States. And that answer will determine the constitutional status of somewhere between 20 and 43 million AR-15 platform rifles currently in civilian hands across this country. To understand why this case is as significant as it is, and why the Supreme Court finally took it after years of refusing to, you have to go back to 2008, not to the AR-15, to the case that created this problem in the first place. District of Columbia versus Heller, 554 U.S. 570, decided June 26, 2008. Justice Antonin Scalia, writing for a 5-4 majority, held for the first time in American history that the Second Amendment protects an individual right to possess firearms for traditionally lawful purposes, including self-defense in the home. That was an enormous ruling, but what Scalia gave the gun rights community with one hand, he complicated with the other. And that complication has been driving litigation for 18 years. Scalia wrote that the Second Amendment protects arms that are in common use at the time for lawful purposes. That is the common use rule. Under that standard, if a weapon is widely owned by law-abiding citizens for lawful purposes, the Second Amendment covers it. The government cannot simply ban it because it finds it alarming. But Scalia also wrote something else. In the same opinion, he stated the Second Amendment does not protect weapons not typically possessed by law-abiding citizens for lawful purposes, such as short-barreled shotguns. And in a passage that has been cited in virtually every assault weapon ban case ever since, he wrote that the government may ban M16 rifles and the like as weapons most useful in military service. Now read those two passages back to back. The first one says common use is the test. The second one implies there is a military weapons carve-out that can override the common use test. And the AR-15, which is the most widely owned centerfire rifle in the United States, not fully automatic, not issued by any military as its service weapon, and not a machine gun by any legal definition, sits directly in the intersection of those two passages. Which one controls? Is the AR-15 in common use for lawful purposes, and therefore protected? Or is it close enough to the M16 to fall into the military use exception, and therefore not protected? That is the question. 18 years of lower court litigation has not answered it consistently. And in 2022, when the Supreme Court issued New York State Rifle and Pistol Association versus Bruin 597 U.S. 1, adding its historical tradition test to the Second Amendment framework, it still did not answer the AR-15 question. It handed the lower courts a new analytical tool and left them to apply it to assault weapon bans. What followed was frankly a mess. Let me walk you through what the lower courts actually did AOWARO, because this is the body of law the Supreme Court is now going to review, and some of it is genuinely difficult to defend. The lead case out of the Seventh Circuit is Beavis versus City of Naperville, decided November 2023. This is the decision that directly generated Viramontes. A 3-judge panel held that AR-15 style rifles are not protected arms under the Second Amendment at the first step of Bruin's analysis. The core reasoning: the AR-15 is almost the same gun as the M16 machine gun. The only meaningful distinction, the court said, was that the AR-15 has only semi-automatic capability, while while the M16 can fire on both semi-automatic and automatic settings. The panel characterized that distinction as minor, and on that basis concluded the AR-15 may be treated in the same manner as the M16 under Heller. Not protected, the government can ban it. The Second Circuit reached the same conclusion, upholding Connecticut's ban. The Fourth Circuit, sitting en banc, upheld Maryland's assault weapon ban in Bianchi v. Brown, 111 F.4th 438, decided 2024, producing a dissent that accused the majority of defying Bruin entirely. The Ninth, the First, the D.C. Circuit, every circuit that addressed the question upheld the bans. That is a unanimous circuit consensus, and the Supreme Court is now reviewing it anyway. That does not happen by accident. When the Supreme Court grants cert to review a unanimous circuit consensus on a constitutional question, it is almost always because the court believes the circuits got it wrong. Not always, but almost always. The dissenting voices at the Supreme Court level have been unambiguous. Justice Clarence Thomas, in a 2024 statement on the denial of cert in Harrell v. Raoul, an earlier Illinois challenge, accused the Seventh Circuit of contorting its Second Amendment jurisprudence, crafting a contrived limitation on protected arms, and reaching a nonsensical conclusion. Those are not gentle words. That is a justice telling you exactly how he reads the lower court decision. Justice Brett Kavanaugh, in a 2025 statement accompanying the denial of cert in Snope v. Brown, the Maryland challenge that came to the court one term before this one, wrote that semi-automatic handguns and rifles are distinct from automatic firearms, such as the M16 automatic rifle used by the military. He added that Americans today possess an estimated 20 to 30 million AR-15s, and that there is a strong argument that AR-15s are in common use by law-abiding citizens and therefore are protected by the Second Amendment. He described the lower court's reasoning as questionable. Kavanaugh was the fifth vote. He was also telling you where he thinks the merits go. Now let me tell you who is actually bringing this case, because that matters too. The lead plaintiff in Viramontes versus Cook County is Cuthberto Viramontes, a Cook County, Illinois resident who filed suit in August 2021. The law he is challenging is Cook County's assault weapon ordinance, first enacted in 1993 and revised in 2013. That ordinance lists 125 specific rifle models prohibited by name, including the AR-15 and the AK-47. On top of the named ban, it adds a feature-based prohibition that sweeps in any semi-automatic rifle capable of accepting a detachable magazine that also has any one of the following: a pistol grip, a folding or thumbhole stock, a barrel shroud, a flash suppressor, or a grenade launcher mount. Violation of that ordinance is a criminal offense, up to 6 months imprisonment, minimum $5,000 fine. Cuthberto Viramontes wants to purchase an AR-15 style rifle for self-defense. He cannot do so legally in Cook County, Illinois. That is his case. Joined alongside him in Viramontes are the Firearms Policy Coalition, the Second Amendment Foundation, and a second private citizen named Christopher Kaya. The companion case, Grant versus Higgins, challenges Connecticut's statewide assault weapon ban, enacted in the immediate aftermath of the December 2012 Sandy Hook shooting and expanded since. Connecticut's law bans commonly owned semi-automatic rifles both by specific name and by feature set, a broader definitional approach than most state bans. It makes possession of a covered rifle acquired after April 3, 2013 a felony. The Second Amendment Foundation and the Connecticut Citizens Defense League are the organizational plaintiffs in Grant, joined by 3 private citizens. The court granted cert on the question presented in Viramontes and consolidated Grant alongside it for 1 total hour of oral argument. All future filings run through the Viramontes docket, case number 25-238. The petition was distributed for conference 22 times between November 2025 and June 29, 2026, before the court finally acted. 22 times. That is not a case the justices were ignoring. That is a case they were working through carefully before deciding to take it. Now let's get into the actual legal question, because this is where the argument is going to be decided a waro. And I want you to understand both sides with the same level of precision, because both sides are making serious arguments. The core question is what lawyers call a Bruin Step 1 question. Under the Bruin framework, the test the Supreme Court established in 2022, a court must first ask whether the Second Amendment's plain text covers the conduct being regulated. If it does, the conduct is presumptively protected. If it does not, the Second Amendment analysis stops there and the regulation stands. The fight in Viramontes/Grant is almost entirely at step 1. Does the plain text of the Second Amendment, the right of the people to keep and bear arms, Cover the AR-15? The plaintiff's argument is straightforward. AR-15 platform rifles are in common use by law-abiding citizens for lawful purposes. Americans own somewhere between 20 and 43 million of them, depending on which estimate you use. That makes the AR-15 the most widely owned centerfire rifle in the United States. Under Heller's common use standard, that is what the analysis requires. The rifle is commonly owned. The rifle is used for lawful purposes: hunting, sport shooting, home defense, training. That ends the inquiry at step 1. The AR-15 is an arm, protected by the Second Amendment's plain text. The plaintiffs go further. They argue the circuit's indistinguishable from the M16 reasoning is factually wrong and legally unsupported. No army in the world uses a purely semi-automatic rifle as its primary service weapon. The M16 fires on both semi-automatic and automatic settings. The AR-15 fires only semi-automatically, 1 round per trigger pull every time. The distinction between semi-automatic and fully automatic fire is not minor. It is the most fundamental operational distinction in modern firearms law. The National Firearms Act itself treats that line as dispositive. A weapon that fires automatically is a machine gun. A weapon that fires semi-automatically is not. The Seventh Circuit in Bevis essentially erased that line, and Heller did not authorize them to do that. The plaintiffs also argue there is no reserved for military use exception anywhere in the Second Amendment's text, in Heller or in Bruin. The passage Scalia wrote about ME16 rifles was a passing observation about historical tradition, not a freestanding constitutional rule giving the government authority to ban any weapon with military design heritage. Virtually every firearm in American history has military design heritage. The 1911 pistol, the bolt-action rifle, the .30 0-06 cartridge. If military origin eliminates Second Amendment protection, the government can ban most of what's in your safe right now. Now here's the government's argument, and I want to give it to you straight because it is not frivolous. The states defending these bans argue that Heller itself created the military weapons carve-out. Justice Scalia explicitly said the government may ban M16 rifles and the like. The phrase "and the like" is doing significant work there. It means weapons sufficiently similar to fully automatic military weapons in capability and design. The AR-15, the states argue, fits that description. Same operating system, same core design, same external appearance. Different only in that one setting on the fire control group has been removed. The states also argue the common use test cannot be satisfied simply by counting how many units manufacturers have sold. If common use is determined by sales volume alone, gun manufacturers can flood the market with any weapon before state legislatures respond, and that weapon then becomes constitutionally immune from regulation. The states argue that is not what Heller intended, and that common use must include some consideration of whether the weapon is suited for the lawful purpose that the Second Amendment was designed to protect: individual self-defense. And on that point, they argue, the AR-15 is not meaningfully more useful for self-defense than a standard semi-automatic handgun or a conventional hunting rifle. Research on defensive gun uses, des and all des events where a firearm is used in self-defense, consistently shows an average of fewer than 3 shots fired. The AR-15's capacity and rate of fire, the states argue, go well beyond what the Second Amendment's self-defense purpose requires. The weapon's unique danger, its capacity to cause mass casualties rapidly, takes it outside the category of arms protected for individual self-defense. Those are the two arguments. Now let me tell you the 2 sub-questions buried inside the main question, because the court is going to have to resolve both of them to write a coherent opinion, and they are genuinely difficult. Sub-question 1. Where in the Bruin framework does the common use inquiry actually occur? Is it a step 1 question, meaning the plaintiff has to establish common use before the Second Amendment even applies? Or is it a step 2 question, meaning if the Second Amendment applies, the government has to disprove common use as part of its historical tradition burden? The circuits have split on this. It determines who has to prove what, and it determines how hard it is for states to ban weapons going forward. Sub-question 2. What does lawful purposes mean under Heller? The states argue self-defense is the core lawful purpose and that the AR-15 is disproportionate to that purpose. The plaintiffs argue lawful purposes include hunting, sport shooting, training, and the militia readiness purpose the Second Amendment was originally designed to serve. You do not have to fire a weapon in a defensive encounter for it to serve a lawful purpose. The deterrent effect of ownership itself is a lawful purpose. The court is going to have to clarify this, and whatever it says will have consequences far beyond this case. Now let's talk about what is actually at stake in terms of geography and scope, because this ruling will not just affect Illinois and Connecticut. As of July 2026, 12 states have enacted statewide assault weapon bans: California, Connecticut, Delaware, Hawaii, Illinois, Maryland, Massachusetts, New Jersey, New York, Oregon, Rhode Island, and Washington. Add Virginia, ban effective July 1st, 2026, the day after cert was granted. Add Colorado, ban effective August 1st, 2026. That is 14 jurisdictions with active assault weapon bans, covering tens of millions of Americans, all of which will be directly affected by whatever the Supreme Court says in Viramontes/Grant. I want to spend a moment on Virginia and Colorado specifically, because their timing creates a legal situation worth understanding. Both states passed their bans under the assumption, an assumption shared by most legal observers at the time, that the Supreme Court was unlikely to take an AR-15 case anytime soon. The court had denied cert in Harrell in 2024. It denied cert in Snope in 2025. The pattern suggested the court was going to let the lower courts continue developing the law before stepping in. Then, 11 days after Virginia's ban took effect, and 3 weeks before Colorado's ban was set to take effect, the Supreme Court granted cert. Gun owners and FFLs in Virginia and Colorado are now in a direct collision course with a pending Supreme Court ruling. Both laws are currently in force and enforceable. No court has issued an injunction in either state, but there are now strong grounds for emergency injunction motions in both jurisdictions, and I would expect those to be filed. The magazine ban connection also matters here. The court deliberately did not grant cert in Duncan versus Bonta, California's challenge to the 10-round magazine limit, or Gators Custom Guns versus Washington alongside Viramontes/Grant. Those cases were passed over at the June 30th cleanup conference and carried to the long conference on September 28th, 2026. There is a reason for that sequencing. The magazine question rides on the rifle question. If the Supreme Court rules that the AR-15 is constitutionally protected because it is in common use for lawful purposes, the argument that a standard capacity magazine feeding that rifle is not protected becomes significantly harder for any state to sustain. The court is holding the magazine cases in reserve, waiting to see what the rifle ruling looks like before deciding whether to take them up separately or fold them into the same term. Let me give you what I can tell you about how this court is likely to approach the question not as a prediction, but based on documented statements from the justices themselves. Justice Thomas has already called the Seventh Circuit's reasoning in Bevis nonsensical, contorted, and built on a contrived limitation on the Second Amendment. He has dissented from every cert denial in this line of cases. His position on the merits is as close to documented as a justice's position can be before an argument is heard. Justice Kavanaugh wrote in 2025 in his statement on Snope that semi-automatic rifles are distinct from automatic firearms such as the M16, and that there is a strong argument AR-15s are constitutionally protected. He is the fifth vote. He telegraphed those views in writing, under his name, in the official United States reports. That is not a casual statement. Justice Alito authored the majority opinion in Woolford versus Lopez, decided just 5 days before this cert was granted, enforcing a strict reading of Bruin against the state of Hawaii. He joined the Thomas statement in earlier cert denials urging review of Illinois's ban. On the other side, Justices Sotomayor, Kagan, and Jackson are the known opposition. Two of those three justices wrote separately in United States versus Hamani, decided June 18, 2026, to argue that Bruin's history and tradition test is unworkable and should be replaced with means-end scrutiny. They are not going to find the AR-15 constitutionally protected. They will push hard for the dangerous and unusual exception. That leaves Chief Justice Roberts and Justice Barrett as the key variables. Roberts has voted with the Bruin majority in every major Second Amendment case since 2022, but he has consistently preferred narrow rulings over broad ones. Barrett joined the majority in Woolford and in Rahimi, but has not signaled specifically on the rifle question. These are the two votes the outcome may turn on. And both of them were part of the court that just chose to grant cert. Justices do not vote to grant cert on a question they intend to answer against the party that brought it. One more thing about the cert grant itself that I think is being underreported. The Supreme Court denied cert in Snope versus Brown, a Maryland AR-15 challenge, in June 2025. 1 year later, it granted cert in Viramontes/Grant. Something changed in those 12 months. Either the unanimity of the circuit consensus was not producing the clarity the court had hoped lower courts would generate, Or enough justices concluded after reading the full Viramontes record, developed after years of district court proceedings, including a multi-day bench trial in the companion case, that the lower courts are simply getting this wrong. The petition for Viramontes was distributed at conference 22 times. The justices read this case, they considered it, and then they took it. Here is where things stand procedurally right now, and what you need to watch over the next 12 months. Cert was granted June 30th, 2026. Briefing schedules have not yet been announced. The October term 2026 begins October 5th. Expect the court to set the plaintiff's opening merits brief within 60 to 90 days, likely due in October or November. The government's response brief would follow 30 to 60 days after that. Amicus brief coordination is already underway. Expect briefs from the NRA, Gun Owners of America, the Firearms Policy Coalition, the Second Amendment Foundation, the National Shooting Sports Foundation, state attorneys general from both sides, and very likely the United States Solicitor General, whose position under the current administration will be worth watching closely. Oral argument is expected in November or December 2026. A decision will come before the term closes in June 2027. In the meantime, watch Virginia and Colorado for emergency injunction motions. Watch the September 28th long conference for whether the magazine cases, Duncan versus Bonta and Gators Custom Guns versus Washington, get pulled into this term or held another year. And watch whether NAGR versus Lamont, the Connecticut Combined Rifle and Magazine Challenge that was held over alongside Duncan rather than consolidated with Viramontes, eventually gets folded into the same argument or held for a separate case. And I want to close on what I told you at the top, because I want you to carry it out of this video with the same clarity I gave it to you going in. Every assault weapon ban currently on the books remains fully in force. The cert grant changed nothing about the current legal status of these laws. Gun owners in California, Illinois, New York, Maryland, New Jersey, Connecticut, Virginia, Colorado, and every other banned state must comply with the current law of their state. Do not act on the assumption of any particular outcome from the Supreme Court. Courts have ruled against gun rights advocates before, including on questions the community was certain it would win. The only thing that changes your legal obligations is a final ruling or an injunction entered by a court with jurisdiction over your state. Neither of those exists yet. What does exist, for the first time in the 18 years since Heller created this question without answering it, is a date, a term, a docket number, and a court that chose, after 2 decades of lower court conflict, to take this up themselves. The Supreme Court has never, in its history, directly ruled on whether a state can ban a semi-automatic rifle owned by tens of millions of law-abiding Americans. Every lower court decision that has purported to answer that question has done so without final guidance from above. That changes with Viramontes versus Cook County and Grant versus Higgins. By June 2027, the most important Second Amendment question left open by Heller will have a definitive answer. What that answer is will define the constitutional status of the most commonly owned centerfire rifle in America, in every state, in every circuit, for every gun owner who has one, or wants one, or is being told right now they cannot have one. That is the case. That is what is at stake. And that is what you need to understand about what happened on June 30th, 2026.